A very good evening to you, ladies and gentlemen. I'm excited to welcome you all to the sixth BASL Professional, Personal and Career Development webinar series organized by the BASL Professional and Career Development Committee 2021-2022. This is the sixth webinar of this fourth webinar series hosted by the BASL and conducted on the Zoom platform. And for those who have been unable to register via Zoom, you can always join with us by watching the live stream on the BASL YouTube channel. This webinar is organized by the Seminars Committee of the BASL, and I would like to thank the Secretary of the BASL and the Chairman of the Seminars Committee, Mr. Rajiv Amarasuriya, Convener of the Seminars Committee, Assistant Secretary BASL, Mr. Pasindu Silva, and the co-conveners, Mr. Pandula Vanyarachi, Mr. Oshan Tharakuberatna, Ms. Anne Devananda, and Ms. Nikini Mapitigama for organizing this webinar on lawyers as negotiators. I would also take this opportunity to thank the President of the BASL, Mr. Salia Pires, President's Council, and the other members of the Management Committee of the BASL for all the support and guidance. Today's topic is lawyers as negotiators, and it gives me great pleasure to introduce the esteemed panel for today. Today, we have with us Mr. Chanaka De Silva, President's Counsel, and Mr. Harsha Fernando. I would also like to mention that members joining this session by Zoom may send their questions through the Q&A chat box to reach the host, in other words, myself, so that I can direct the same to our esteemed panelists. Now, before we move on to today's session, I would like to introduce our panelists. We have with us Mr. Chanaka De Silva, President's Counsel, and he's considered the foremost legal expert in the field of project finance transactions and negotiations in Sri Lanka, and his expertise further extends to the field of litigation and alternate dispute resolution. Mr. Chanaka De Silva commenced his legal career as a state counsel in the Attorney General's Department of Sri Lanka, where he served during the period of 1987 till 1996, prior to forming Nitya Partners in 1997. During his tenure at the Attorney General's Department, in addition to specializing in banking and commercial law related litigation, Mr. De Silva advised the government of Sri Lanka on various matters involving infrastructure development, project finance, restructuring, and corporatization transactions. For over 30 years, Mr. De Silva has been involved in advising, negotiating, and structuring major infrastructure projects in Sri Lanka, spanning a multitude of sectors such as electricity, telecommunication, petroleum, roadway, ports, and mining. He was also the legal advisor in most major privatization of state entities by the government of Sri Lanka. Mr. Chanaka De Silva was the senior legal consultant to the Secretariat for Infrastructure Development and Investment and its successor, the Bureau of Infrastructure Investment. The work in this position involved advising the government and the relevant governmental agencies on large-scale infrastructure projects, including the preparation of requests for proposals, selection of preferred bidders, and the negotiation of project agreements. He has also served as a legal advisor to the Public Enterprise Reform Commission of Sri Lanka relating to the public enterprise restructuring and privatization processes. Mr. Chanaka De Silva has functioned as a legal advisor in a majority of the large independent power projects in Sri Lanka. The privatization of the Queen Elizabeth Square, the establishment of the South Asia Gateway Terminals, and the structuring and implementation of the Hambantota Port project. He was also a member of the team of consultants on the development of the Colombo-Katunayaka Expressway and the National Telecommunication Backbone Network for Sri Lanka. He has also acted as a local legal expert on public-private partnership for several multilateral development banks. Mr. Chanaka de Silva leads the firm in handling specialized litigation and is known for his expertise relating to complex disputes in corporate, commercial, banking, finance, infrastructure projects, telecommunications, power and energy, insurance, construction, and intellectual property matters. Mr. Chanaka de Silva has been consecutively ranked as a leading professional in the field of project and energy by the Legal 500 Asia Pacific for the years 2010 onwards. In recognition of his consistency of excellence, in March 2020, Mr. De Silva was inducted to the Hall of Fame of the Legal 500 on projects and energy. He has also been ranked as a leading individual in dispute resolution by the Legal 500, Chambers and Partners, and IFLR 1000. We warmly welcome Mr. Chanaka de Silva, President's Counsel, for our session today. We also have with us today Mr. Harsha Fernando, who is an attorney at law with over 25 years of experience. He is the head of his own law chambers, providing legal services, consulting and litigation, specializing in civil, commercial, regulatory, and public law. He also offers commercial negotiation and mediation services and provide training and strategy consulting in contract negotiations, legal and legal risk assessment, governance, and institutional design dynamics. He is also a specialist in ADR and negotiation, working as a consultant and trainer with the Sea Change Partners of Singapore, Accordance Incorporation, USA, and has conducted corporate training and offered consulting services in a number of countries in Europe and Asia. Mr. Fernando is an international consultant to the Asian Development Bank and has provided consulting services in several sectors, including roads, energy, environmental law, justice and public finance management in Sri Lanka, Nepal, Vietnam, and Myanmar. He has provided consulting services to the World Bank, International Organization for Migration, European Union, and the United Nations Development Programme in governance, anti-corruption procurement, public finance management, and project design, finance and management. He worked with Sri Lanka's Right to Information and the National Procurement Commissions. Mr. Fernando was a visiting resource person to several institutions, local and overseas, including the Queen's Mary University of London, International Development Law Organization, Rome, and Postgraduate Institute of Management, University of Sri Jayawardhanapura, of which he was a member of the Board of Management. He was also a consultant to the International Securities Consultancy of Hong Kong. In Sri Lanka, Mr. Fernando was a senior state counsel at the Attorney General's Department during the period 1997 till 2011. He was also a legal advisor to the Central Bank during the period 2003 to 2005, and a legal advisor to the Office of the Prime Minister and Telecommunications Regulatory Commission. His services were obtained as an expert to the Constitutional Assembly Judiciary Subcommittee of the Parliament of Sri Lanka in 2017. Early on in his career, he was also an industrial relations advisor to the Employers Federation of Ceylon in 1996. Mr. Fernando read law at Sri Lanka Law College in 1995 and holds a Master's in Business Administration from Nanyang Technological University of Singapore, an Executive Master's in Management from Massachusetts Institute of Technology, MIT, and a Master's of Law in Regulatory Law and Economics from King's College, University of London. He is a Chevening Scholar of the Foreign and Commonwealth Office, United Kingdom in 2003. He's also a Nanyang Fellow of Singapore in 2000 and secured the Most Outstanding Young Person of the Year award for legal administration in 2011 from Junior Chamber International. Mr. Harsha Fernando has authored a number of articles and made presentations both nationally and internationally, covering a wide array of subjects. We warmly welcome Mr. Harsha Fernando for our session today. And I would now cordially invite Mr. Harsha Fernando to start the panel discussion by introducing what negotiation is and the role of a lawyer.
Thank you very much for that very long introduction. So straight away to getting to the topic. I've been told that this topic has generated a significant amount of interest. And I must apologize in advance, and I'm sure Chanak also will join me in sharing these sentiments. It's a very difficult task to convey the full potential of the subject that is under discussion within a short presentation of this nature. So what we will hopefully try to do is to give you a different perspective and perhaps get you to think about how you probably perceive yourself and this topic called negotiations, and particularly how it relates to your day-to-day work as a lawyer. So this presentation will have two components. My presentation will have two components. One is I'm aiming it at practitioners, the day-to-day practitioners who go to court, which can include judicial officers, as well as legal service professionals who are not in the litigation side, but providing transactional and advisory services in their capacities as lawyers. So I have prepared a short presentation, and if I may share it, I'm going to switch from one slide to the other. It will not go in a sort of a logical sequence, so please forgive me for that too. But let's see how we can start. So what I will do is I will start with a slide that I got from a former junior colleague of mine who worked in my chambers. The moment he saw this notice, he sent me a SMS asking me these 4 questions. So extent of the relevancy of the negotiations in the legal profession and attorneys' duty to court. Should attorneys negotiate with clients prior to or during litigation? Should be done prior to coming to court? Is negotiating with the opposing counsel's client violation of ethics? And negotiations are used for unlawful and unethical purposes. How can this be addressed? So these are 4 questions that I got this morning. So I'll just leave it at them because it gives a one aspect of the negotiation perspective that some lawyers think about. I will come back to that hopefully at the end of my presentation. Now, the most important thing is when you said negotiators and lawyers, for the longest of time, some thought that these two roles kind of don't go together. I take a different view. And the view I take is it depends on your definition of negotiations. Now, when I use the word negotiation, I'm not talking about deal making. When I use the word negotiation, I'm talking about a strategic approach to influence. That's what I mean by negotiations. So if you actually think about your normal roles without going too much into detail, so you have your litigation roles. So you have 2 areas that you can choose as a professional, either litigation work or transactional work. Now, if you take litigation work, every time you get up and make a submission to a judge and try to influence that judge to see your presentation and your interpretation of the facts and your interpretation of the law as against the alternative viewpoint put forward by the opposing counsel, what you're doing is you're negotiating with the judge and trying to influence him to make a decision to hold a particular thing in your favor. If you are in transactional law, then what you are in effect doing is you are using your superior, I'm using the word advisedly, superior skill set and knowledge to try and bring about more value to the client who retained your services. Now, although we keep these two kind of separate for purposes of division, actually they're actually interconnected. Because one phrase that I've learned from Mr. Chanaka De Silva when we first did a presentation together on contract negotiations almost 20 years ago. And I'm using that phrase without necessarily attributing the intellectual property rights to him. But basically what he said was, a legal contract is a business arrangement. A legal contract is a business arrangement. Now, business arrangement, I'm sure there is no doubt, involves a lot of negotiations, whether through an agent called a lawyer or by the parties themselves directly. So what lawyers do, if you are into transactional law and you come in at the tail end of the process, is that you put it into some legal form, whatever the business arrangement that these two clients have put together. So either way, when you go to court, the litigation side of law, when you go for especially a civil case, what necessarily, when somebody says that they have gone to court, what they really say is, something has gone wrong in our business arrangement. We are not in a position to deal with this on our own. So now we are seeking the intervention of a third party, in this case, a court, to resolve and help us to resolve our dispute. Now, unfortunately, I will demonstrate you in a short while. The dynamics of the court process doesn't necessarily see it the same way that it should be seen. So at that point, whether you are negotiating the deal for the client or trying to help your client to manage whatever the conflict that has arisen out of that deal, they need lawyers. So if I may very quickly take you why I think lawyers are important, I see us bringing us value at 4 main areas. In our knowledge, because of the legal system, certain procedural and substantive moves that we have. Then we have certain resources we bring which an average layperson may not have: access, networks, our own reputation. Then, of course, hopefully the skill set, our communication skills, our ability to deal with issues dispassionately and objectively. And finally, some strategic value addition, problem solving, which may not necessarily be available to the clients. I mean, some clients at least. So if you think about it, you need to see yourself as bringing in a value addition to the client. And if you're not doing that, then of course, your role of a lawyer has to be rethought. Now, if this is the kind of skill set you're bringing in, and if you remember what I said about the earlier part, that what a lawyer necessarily does is help a client to negotiate a better deal, enhance value, and help him to deal with a dispute that arose out of a business transaction they put in place, then the lawyer's role becomes clear. And in that role, I don't think we need to argue that skills in influencing, skills in negotiations, which I again said is a strategic approach to influence, has to be a core and a critical skill in the basket of skills that each lawyer has. So why are lawyers needed? I would like to think ourselves as conflict doctors. We should be able to figure out what's going on and then be able to manage the conflict. So at the end of the day, we give a way out to both the clients. You see, it's not about my client and his client. At the end of the day, the two people before you are there either because they want to get together and create more value for themselves, or in trying to do so, they have encountered a problem and they need your help to sort it out. So we can do a few things. I've just listed a few things. I need to not emphasize it. The important thing is, when we talk about conflicts, which is our business, we are in the business of conflict, we tend to think of it in negative terms. People are fighting, that's why they have come to court, and we get ready for something like a gladiatorial battle in court. Insult the other side, not be disclose necessary information, and do everything, every trick, as I would call, that is available to you, bordering on almost violating ethics, to get the best for our clients. And if somebody finds fault with us, we will always justify it saying, well, I did the best for my client. Now, we get into that fight under the misconception that we are doing so on behalf of our clients who we assume or perceive to be fighting. But one thing that one needs to remember is that people get into conflict not because they are fighting, but because they need each other. If I can get what I want to get without you, I don't have to get into any conflict with you. So if every conflict that you will find in court or that you will encounter in your career as a lawyer, if you really unpack the dynamics, you will realize that that conflict has arisen because one client needs the other to achieve the former client's interests. If it is a supply contract that has gone bad, the purchaser will want the supplier to supply the goods at the quality, at the price, on time, as was undertaken for him to continue his manufacturing process. So he's the other side. So that conflict has arisen because that other person has not done something for you, which stops you from achieving your goal. So the more people fight, I love it, because that means they really need each other. Now, if you can remember that fundamental thing in your mind when you offer your services as a lawyer, you will begin to see yourself, your role, as well as the value addition you bring to the deal very, very differently. Right? So what happens is, I'll just give you, if you go to court, this is basically what happens very quickly. So it's a dispute arises, and finally you need to come up with some sort of a solution. So this is the value chain of a dispute, and you will find points at which all of us offer value. Now, these are the skills lawyers need if you are a court-going litigation lawyer. Right? Just to show you the value addition we can. If we are not bringing this value addition, this is where our fees get justified. Right? This is what happens when a case sort of proceeds. This is, of course, a presentation I got from another presentation I did, so I will quickly go through it. So here, some breach happens. If there is no breach, no problem. We decide to sue. We file a case. If you don't file a case, it ends. And it goes on and on until it appeals and then ends it. But in the meantime, here are the costs to everybody. Transaction costs, man hours lost, relationship costs, efficiency costs to the system. We are responsible for this if we don't see our role and value in negotiation, or the value that we bring, differently. Now, here is the thing that I want to share with you. Now, when we are approached by a client, assuming two ways. One is help them to negotiate a good deal, or the deal has gone bad, help them to manage the conflict. We have several methods that are available to us to deal with this. So this is what I would call a continuum in conflict management. Now, again, you can see that I'm jumping from one slide to the another, and I'm sorry if there is no sort of a smooth flow in this. So the first thing we tend to do is, if there is a conflict, let's take a conflict. If there is some problem between two clients, the first thing that the clients will try to do is they will try to resolve it privately between them. They will try to talk to the other side. So that's here. First is they will try to forget about it, informal discussion. If that doesn't work, they go in for formal negotiations. If that also doesn't work, they will go in for mediation. Now, the next time what you do is, if that doesn't work, you jump into the next category. Here, the parties have a lot of control over what's happening, but moment you go here, you lose control to a large extent, because once the arbitrator gives an award, you're stuck with it. Now, if this is not there, then you go in for a court case or a parliamentary law. Just look at the judicial decision. You go for a court case. If the courts are not working, like for example, you want to get rid of your tenant, and you know that going to court will take a long time, so you will use some sort of a extrajudicial method to get the outcome you're looking for. So very quickly, this is the sum total of all the mechanisms that are available to a conflicting party as well as to us to deal with this. Now, today we are talking about here, but in the context of what we do here in judicial decisions, right? This is not my own thing. This is I got it off a good textbook on mediation. Now, the important thing that what one must remember is that each of these methods, if you look at it, there are, they start from here, 1, 2, 3, 4, 5, 6 methods that are there. Each of these methods have a different dynamic, and every conflict doesn't fit into each of these. What I'm trying to say is, when I used the word conflict doctor before, you need to figure out what's the best way to deal with issues that the people are facing. Now, in deciding that, again, a very quick one, if you want to have a lot of control over the outcome, then what you do is you go for mediation, because if you don't like what the mediator offers, you can walk away, but you don't have very much control over procedure, because the mediator will decide how the mediation should work. On the other hand, if you go for arbitration, you can decide how the procedure will work, but once the arbitrator gives an award, you're stuck with it, so you have very little control over outcome. If you go to court, you neither have control over the process, because the civil procedure code decides it, and neither do you have control over the outcome, because once the judge gives a judgment, you're stuck with it. Now, if you want to have maximum of both, we recommend negotiations. Now, that's where I would personally feel that negotiation fits in to the overall roles of a lawyer. Now, I don't think I want to take time on this one slide. I'll slip again. If you take, let me take an example of a commercial contract, and Chanaka will take you in detail into this, and I hope I'm not impinging into his area. But if now, earlier I discussed about going to court and the role that the lawyer can play and how it will work. Actually, I will explain this to you. You see, if you go to mediation and negotiation, what the process entices you to do is they will ask you to get together. Look, both of you got a problem. Both of you came in here because you saw value in coming together and working out a deal, a business deal. Now something has gone wrong. We understand, not in the whole deal, but in some aspect of it. So what mediation and negotiation does is, either by using a third party on their own, that process encourages the two parties to discuss with each other and try to resolve this. Now, this is the point where they come up with really innovative thinking and lots of nice things to do, because they are not constrained by procedures and rules of evidence. They can be as innovative as they want to be. So as a result, what happens is, if you do your mediation and negotiations well, your two clients are going to walk away feeling much more happier, taking away a lot more value than they originally came to the disputant table when the dispute arose. To give you an example, I had a client who came to me, who was a director of a company, shareholder director, and the other directors were not treating him well, and he wanted to exit. But what he really wanted to do was to sue them, to teach them a lesson. So when I asked him what he really wanted, What he really wanted was he has lost control of the company and he was not getting involved in the day-to-day management. And he wanted to start his own thing and then develop it because he was passionate about a particular area. Now, the other directors were worried that he might compete with this current company and have certain inside information. And that was the dispute. Now, when we finally got both the parties to the table through a mediation process, the underlying cause for the dispute was actually a relationship issue. These were 5 friends who started the company. And when the money started rolling in, they couldn't manage that. They sort of lost that. And some felt that others were doing more than the others. And that whole dispute started. But at the end of the day, at the start of my consultations with him, my client said if he was happy, if he can get about 4 million for his shares. We finally did a deal where he was paid 12 million for his shares, plus so many other things which were beneficial for both the companies. So in other words, what they did was they made the value bigger so that when they divided it, both parties walked away with a lot more. But if you go to arbitration and courts, if you think about it, if anybody is involved in litigation law, you start the process by thinking about the judgment. Actually, we work backwards. We go, it's all or nothing approach. I'm going to win this case. I'm going to get everything. There is no question about sharing. I'm going to win. Now, what do I need to do to win? So then you will look at your procedures, your evidence. You will look at the minimum of information being shared. The incentives are that you get ready for a battle, a fight in arbitration or courts. In mediation and negotiation, you do something completely different. So if you subscribe to my original view that lawyers are there to create value, I present to you the challenge of these 2 methods. Which one would you choose if you want to create value for the client? Now, having said that, there are certain disputes that you may need to go to court to solve. I'm not for a moment saying that it is not the case. But those disputes, in my opinion, are very few. Because if you look at the number of cases that gets settled in appeal in the Supreme Court, large. I always ask the question, why did they spend all that money and time and settle it 20 years later in the Supreme Court without doing it in the first day in the District Court or the Commercial High Court? So I suppose they get tired with the process and sick other lawyers or whatever. But lawyers also have got a bad name because of this dynamic. So I'm inviting you to understand this difference and choose for yourself. If you're given the option of these multiple avenues and methods, which method would you rather choose or give priority to if your intention is to bring more value to the client? And trust me, if you bring more value to the client, they'll be happy to pay your fees. So if I may take an example of a commercial contract. Now, if you want to look at value in a commercial matter, approach matters, I say that you will see value in 2 angles. First is there is substantive value. That's the terms of the deal. How much would you pay? What's your profit margin and all that. There is also a relationship value. Because if you need a lawyer, you are not going to get a lawyer when you're going buying something in a touristic location of the gift shop in the hotel. You're not going to need a lawyer for that. But if you're going to through a deal that is going to last for 3 years, a supply contract, or if you're going to do a share purchase for a merging of 2 companies, you're looking at a long-term working relationship. So you need to capture both these values to get the maximum. And in today's context, relationship values are huge. Now, unfortunately, the court processes, the way they are designed, because they want to maintain that objectivity, do not leave much room for relationship value to be caught. It's a substance value, and substance value is winner takes all kind of thing, but you have lost out a lot of things I said earlier in terms of your time, cost, reputations, all that is lost. But you might win the case. It's sort of a winner's curse in a way to win a case in Sri Lanka when you consider the time and the cost involved. But this is the value, and I invite you to see value in this way. Give broad terms to value, and let your clients also see value in this way. And it is then that you become a proper conflict doctor and able to manage conflicts. So if I give you a example, you have conflicts and opportunities. Now, if you go to court, here on the left-hand side, under the title conflicts, you will find what you will normally ask for in a court. But if you change your perception on what the conflict is all about, and your role as a lawyer being value creation, you might see it differently. So they want what we want. Opportunities, we can find out what they need. What we want is what we need. There may be other ways to meet our needs. For us to win, they must lose. We might both get what we need. So on and so forth. It's a fundamental change in the way you see value and your role. Now, if you look at a contract, it's basically a legally enforceable business arrangement to create value for parties. Now, if you agree with the words create value, then automatically you need to look at the definition of negotiation, which I say is a process by which you reach this value creating arrangement. Now, if you are doing contract negotiations, now I'm getting into transactional law point of view, there are several roles you can play. You can be a negotiator where you actually negotiate on behalf of the client. You can be an enabler where you create an enabling environment. You can be a mediator when parties cannot reach agreement. You can be a problem solver, you can consolidator, you can be an expert. At the end of the day, if you want to be that, expert lawyer, that person that you want to be Mr. Chanaka de Silva, you need to be this high quality, user-friendly lawyer who understands the difference between commercial decisions and legal rules to create value. Right? Now, if you see that way, some of the questions that my former colleague posed in the first slide that I showed you, some of those conflicts will not arise because you can nicely align your role with what you should be doing. So in a value creation process, this is the substance. You need to sort of take all these three into account and then move forward. This is what I call the negotiation dynamics. Now, this is a very advanced subject. For example, I do negotiation training, and the method I use is what we call the interest-based negotiation method. That was populated by the Harvard Law School. It's almost a compulsory subject for Harvard Law grads. Now, that I teach over 2 to 3 days. If I'm teaching in a university, it takes about a month. The reason I said so was to impress upon you that this is not something that you can learn in a hurry. But if you have any doubts whether you're a good negotiator or not, don't have any doubts, because negotiation is both an art and a science. If it is a science, it can be learned. And if it can be learned through science, and if you internalize it over a period of time, it will become an art. So that at the end of the day, what are the key messages that I will bring to you? Think of your legal knowledge that you learn at law college. The second is, how do you convert that legal knowledge in a way that creates value to you, to your client, and to the world at large? Now, to do that, one powerful way is through negotiation, a separate skill and a separate way of looking at things. Okay, so this is the system of legal. I won't go into that. I will leave you with this, and we come back again after listening to Chanaka. But I'll leave you with this thought: you don't get what you deserve; you get what you negotiate. Thank you.
Thank you, Mr. Harsha Fernando, for that valuable insight. I now cordially invite Mr. Chanaka de Silva, President's Counsel, for the presentation.
Thank you very much, Harsha, for that excellent presentation. I always enjoy the way you make that presentation. It makes negotiations very understandable to everybody. Now, my presentation is going to be slightly different from Harsha's presentation. I do not have a prepared presentation actually. So I will basically be discussing certain principles that relate to this particular aspect. So first of all, let's look at what is negotiating, or what is the object of negotiating. Right? What are we trying to achieve by negotiating? If you look at any definitions, you will find them as describing, the words which describe negotiating is basically obtaining or bringing about something by discussion, or finding a way through a process by discussion. So if you really look at what negotiation is, it is basically a dialogue between two or more parties with the intention of reaching a beneficial outcome for both parties. Now, that is what I think is most important for us to understand. So in this context, if you look at what is not negotiating, you might understand it better. Negotiating is not bargaining. Bargaining is something that you do in a parlor. Negotiating, on the other hand, is understanding the other party, discussing with the other party, presenting your problems or issues with that other party, and trying to achieve a result which is beneficial for both parties. Negotiation is also not taking a draft of a document that has been prepared by somebody else for some other contract and changing the grammar, changing a few clauses, and putting together a contract. That is not negotiation. Far from it. Negotiation is also not winning at all costs. Winning at all costs is essentially something that you do in a battle. And we fight our battles in court also. But like Harsha said, one party wins and one party loses. One party is very happy, the other party is unhappy. And you can be assured that you're not going to go too far with your transactions. So therefore, when you look at these two, what is the object of a negotiation? It is to bring about a good result for both parties by a discussion. And it is not winning at all costs. I think we understand essentially what negotiation is. So why do you negotiate? Essentially for two reasons. One, you either are involved in a discussion or dispute, and therefore you need to bring about a resolution for that. Or on the other hand, you want to do a transaction, a deal with another party. And for that purpose, you are trying to achieve a transaction through a discussion. Now, so therefore, essentially, negotiation is trying to arrive at a compromise for the purpose of accommodating the ideas, rights, likes, and dislikes of all parties, if I may put it that way. Right? Then why do you negotiate? What is so important about negotiation? Negotiating, I told you, is essentially for the purpose of achieving success. Success not of one party, but success of both parties. Why do you do a transaction? Why do you negotiate a transaction? You negotiate a transaction so that you and the other party both can do business and enjoy the success of the business that you're doing. It may be buying and selling a commodity. It might be doing a service for your client. We also, as lawyers, do negotiations even for the purpose of doing a case, when we undertake a case, or when we go to court, like Harsha explained. Or on the other hand, if there is a dispute, to bring about a reasonable resolution for both parties. So what are you trying to achieve? You're trying to achieve, I would say, one of three things, or almost all three things. One, you are trying to deliver a lasting solution, a durable solution to your parties, your clients. It might really be a business transaction, which is lasting. Or it might be a solution to a dispute, which is acceptable to parties and which is lasting. Secondly, the negotiation will avoid future conflict. So whether you're doing a negotiation for the purpose of doing a transaction or for the purpose of resolving a dispute, if you spend time on it, if you do it properly, it will avoid future conflict. Now, this is something which is very important to understand. Sometimes negotiations take a long time to conclude. Now, some of the transactions I have done, parties have negotiated for 3 years. But after the 3 years, they do a 35-year contract without disputes. Why? Because they have negotiated all related aspects to it. So therefore, each party knows what has to happen when something happens. Now, if they did not do that, there might be areas which are vague. And during your 35-year contract, you will have 100 disputes. Now, was it not worth the 3 years that you spent negotiating that transaction? So very often we discount this. And I think we as lawyers, when we advise our clients, we need to impress this upon them. That often it is better for us to discuss and iron out vague areas and have solutions to those issues which may arise, rather than leave them open, allowing disputes to take place. The third aspect really is basically, like Harsha said, building relationships. If you had a conflict, if the conflict is resolved, both parties walk out of the place happy. If they want to do business together, their original business went sour, they have now entered into a settlement, maybe they can do business again. Or even if they don't want to do business again, they can at least be civil to each other. On the other hand, if you are negotiating a deal, the transaction, once you do the transaction, you build a lasting relationship on which you can build on. And I think this is something which is very important for us to understand. And that is why we need to really understand and take into our account the fact that when you are negotiating, you should never walk into a negotiating table with the idea that I will win. Because if that happens, you are not going to have a long-lasting transaction. So, what are the skills that you need to develop if you are to be a successful negotiator? I think one skill would be paramount. You would understand this immediately. Patience. You need to be patient. You need to be a person who can listen. We lawyers are used to talking a lot. But when we are doing a transaction, we must be willing to listen to the other party as much as we talk. Because if it is only when we listen, we understand what their issues are. So therefore, the third aspect that you need to be is an understanding person. If you're always pushing only your side and you don't really see their side, it's very difficult to strike a deal or come to a compromise. So you need to be able to understand and accommodate the other party. So therefore, you need to be open-minded for this purpose. You need to be able to accept that just as much as you have a certain position, the other party also has an equally valid position which they are articulating. After all, if not for that, they would have agreed with you. Right? So you need to be open-minded, you need to be understanding in order to negotiate. These are very important personal skills. Next, ability to work in a team. Very often, if you're negotiating fairly detailed transactions, this is not necessarily so in court, but very often even in court, you need to understand that we as lawyers, that we don't know everything relating to the matter. Very often we don't know much. We might be the biggest actor there, but our knowledge in relation to the matter that we are handling might be very limited. It might be a matter which involves a lot of accounts. And we are lawyers, we know law, we don't know accounts. So we need to get that input from the guys or people who know accounts. On the other hand, we might be doing a transaction in relation to a very technical matter. It might be a telecommunications related one. It might be a software related one. It might be a construction related matter. And we are not telecommunications people, software people, nor construction people. And there are experts at that. We need to work with them. We need to understand what they're saying. And we need to work with them as a team. So if we assume that we know everything, I don't think we will go too far. So this also means you must have the ability to learn. Because from transaction to transaction, you will be moving from one type of matter to a different type of matter to a third type of matter. And even if you look at matters in the same subject, they will be different. For instance, if you're dealing with construction contracts, no two houses will be the same. No two buildings will be the same. No two roads will be the same. So therefore, every time we do something, we need to be able to listen and learn. It doesn't mean we have to become experts. It just means we have to take time to understand what they're saying. You also should have the ability to innovate. Because very often, in negotiations, it becomes necessary to innovate in order to bring a resolution to a dispute. Let me give you a simple explanation in relation to this. An example, this is very, very, very nice. I'm sure you would have heard that I do negotiate these power-related transactions. And I was actually negotiating the very first transaction in my life. So there is the power generator and the power purchaser, which is the Ceylon Electricity Board. I was on the side of the Ceylon Electricity Board at that time. And obviously the power generator generates power and sells power. And the question is, how do you measure? And obviously you measure by metering. I mean, even in our households, you measure by metering. So therefore we agreed that we will get meters for this purpose. These are very expensive items. I believe at that time it was about $1 million each. So then the question was, okay, what happens if this meter is wrong? Then we agreed that we will get what is called a check meter in addition to the main meter. So you have a main meter, you have a check meter. So parties are quite happy until suddenly one person said, okay, that's fine. What if both of these are not properly calibrated? So then my reaction was, it can't happen, right? You calibrate them occasionally and then you have a main meter, you have a check meter. How can both go wrong? And these guys actually said, no, it can happen. Believe me, it can happen. So they themselves came up with a solution, and the solution was a very simple one. They said, okay, every time we read the meters, 2 people will go and read the meters, both parties will sign, and at the same time, we will take a picture with a Polaroid camera and preserve that. Now, lo and behold, 10 years down the line, that particular thing that was contemplated did happen. And both meters were faulty because they were not properly recorded. Both meter readings were faulty. So what did they do? They had to resort to the picture that was taken. Simple solution, innovative solution. I don't think any of us lawyers would have come up with that, right? It took that technical guy to come up with that, right? And that resolved the issue. Right? Now that's innovation. Right? And we need to be able to innovate situations like that or remedies like that in situations which are unusual. Of course, it is always when you're engaging in commercial negotiations or even for that matter, commercial litigation, it is always a good thing for everybody to know how to read a balance sheet and to analyze financial statements. It doesn't mean you have to become an accountant, but you need to be able to know, well, what are the relationships that are there in relation to these documents, right? In today's world, it is very, very important to be multifaceted, multi-talented. That will help you a lot in understanding what your clients are talking about. So, when you do get a client who asks you to negotiate, what should you do? First thing, be prepared. Prepare yourself. Without preparation, never go to a room to negotiate on behalf of your client. What do you mean by preparation? First, you need to understand what the transaction is about. You need to understand what your client's position is and what your client is trying to achieve. What are the risks that your client faces? What possible things can you do to mitigate those risks? You need to anticipate them. Secondly, you're going into a negotiation with another party. You need to understand what is their position. What are they doing? What would they ask for? What are they trying to achieve? And correspondingly, you also would look at what would be our responses to those. So then, first of all, when you're walking into the room, you know what you're talking about. You're ready for the transaction. So without getting prepared, don't walk into a negotiating room. Number 2, set your limits. Understand your limits of authority. Understand what you need to achieve on behalf of your client. Understand what you're prepared to give. Because I told you, a negotiation is a compromise. It is achieving a transaction where both parties are happy. You know, because you were prepared, what the other party is likely to ask you. So therefore, you would know what you would like to achieve. You know what the other party is likely to ask. And you know, therefore, you should be prepared with what you are able to offer them. What is the bottom line? What is the possible scenario? You need to set those before you go into a negotiation. Number 3, don't be inflexible. You can have your top line, you can have bottom line, you can understand what you want to achieve, but don't be inflexible, because at the end of the day, the other party won't behave exactly as you expect. They might come up with something totally different to what you anticipated. And in such a situation, you need to be able to understand what their position is and why they are saying that. And as a result of that, if you need to rethink your position, do that and be prepared to do that. You must be ready for that. And these things do happen in real life every single day. It happens in court. It happens in negotiations. So be ready for that. And after all that, sometimes you might have a deadlock. You ask for something, the other party is just not willing to give it. So how do you get over that? I'll ask you a simple question. You are walking around and you need to get to a particular place and you suddenly see a wall in front of you. What do? Do you stop and turn back and go? Or do you see a way around it? It's the same thing that you need to do when you're doing a negotiation. Not to abandon your trip, but to basically see how you can get around that. So for that purpose, you need to ask the questions: why, where, when, how. And if you ask these questions, you will get a reason, or you will be able to understand why the other party is taking the position that they're taking. And very recently, when I was reading a book, I mean, this is a very, very simple example, a bit of a funny one. Apparently, somewhere around October, I believe, some people were looking at a melon. This must be an American story, right? A melon. And there was only one melon and 3 people were trying to buy it. And you can't, I mean, 3 people can't buy it. So they started talking to each other. And when they started talking to each other, they realized that all of them wanted the melon for different purposes. And those purposes were not mutually exclusive. One person wanted to make a soup out of the center of it. The other person wanted the seeds to plant. The third person wanted the shell for Halloween. So if all 3 of them got together and bought it, they could achieve their end. Very often in transactions also it is like that. People say they can't do something because they face a risk. And very often, if you understand what that risk is, you could remedy the risk. Maybe you could offer them a guarantee of some sort. Maybe the risk is faced only at a particular time. And after that, what you want may be possible. Or you might be able to do something until something happens, and thereafter the risk might materialize. So therefore, in a situation where you are in a deadlock, discussing it asking these questions: how, why, when, where, what. It's not an English lesson, but they basically yield you answers which will probably help you get over that issue. And of course, this all being said, there are those one or two transactions where you actually might have to decide to walk away. Negotiations do not always mean a successful transaction. Sometimes successful negotiations result in the realization that the parties can't have a transaction. Often it is said that some deals are worse than no deals. So you need to be aware of that. And in such situations, it might make sense for you to walk away. Now, in all these contexts, one of the things that I did not articulate or did not say when I said about the skills that you need, is basically general politeness and understanding of the other party. Very often when you start a negotiation, you will find that the other party is very reluctant to talk, very reluctant to give up their positions or give out their positions, articulate their positions. And until you get over that barrier, you're not going to have a proper discussion. And in order to do that, you need to develop confidence. Not only the confidence of your client in yourself, but the confidence of the other party in yourself. They need to understand that you're not going to, take them to the cleaners. You're not here to win at all costs. You're there to do a transaction. And once you build that rapport with the other party, it becomes easy to do a transaction. They will tell you the problems that they have. They will be happy to work with you and come out with a joint solution to an issue. And that is what you must aim at achieving. So, in this background, you need to remember, what is the final objective you're trying to achieve in a negotiation? That is basically obtaining a result that is acceptable to both parties. Whether you're negotiating a dispute, whether you're negotiating a transaction, your objective is to achieve a result which is acceptable to both parties. If you do not achieve a result which is acceptable to both parties, the transaction or the resolution to the dispute that you negotiate is going to be short-lived for sure. Because if one party is unhappy, no transaction, no relationship is going to last. In American language, you call it a win-win situation. In simple terms, it means a transaction or a resolution to a dispute which is acceptable to both parties. So if you really understand that as the main idea or concept of negotiation, then I think you will be able to go forward to do successful negotiations. Thank you.
Thank you very much, sir. I am sure there was a lot to learn, and I know that the time is not sufficient to share all your experience and your valuable insight with all our participants, but let's try to next move on to our questions and answer sessions. All the participants, whoever who has a question to the esteemed panelists, please type in your questions in the Q&A box or even on the chat box so that I can direct it to the panelists. Till we get your questions, Mr. Fernando, I think there were some other questions that you had earlier received from one of the interested parties. Maybe you can start by answering those questions and then we can move on with the other questions.
Okay, let me see whether I can pull those out. Maybe I'll need to share screen again. Yeah, so can you see my screen with which it says a few questions? Yeah, you can see that.
Yes.
Okay, I think you see, I think both Chanak and we feel the challenge because I think we are both very passionate about this subject, and having dwelled in it and studied this for a long time, it's almost parallel to law in terms of the amount of time you need to invest in developing that skill set. I will ask everyone a simple question before I answer these questions. If I ask you to close your eyes and just think about the value of all the deals you were involved in, whether litigation based or contracts you did or the deeds you did or whatever that you did for a client. And if I ask you to put a rupee figure, the total value of everything you did, maybe during the 6 months, even with this COVID, I'm sure it will come to a big amount. Either you are directly or indirectly involved. And if I ask you the question, just imagine if you were able to get 5% more than what you managed to get out of all those deals, how much is that amount worth? That is the value addition that this brings. And I'm sure it will also run into millions. And that is also what is at stake in your negotiations. So the question I would pose to my colleagues, which I do to every person who comes into contact with me in this area of subject, is how much time do you spend learning a skill called negotiations, if that is so important to you, if that is the amount of value that it can bring for you? And most of them, the answer is we really haven't thought of it. How you negotiate is through intuition. If you really think about it, your first negotiation was when you were immediately after you were born. You felt hungry and you cried and you got milk. You learned your first negotiation. The next time when you are hungry, now you know what to do. You cry, the milk got delayed and you increase the volume and the milk came. You learned your second negotiation. Now the problem is, if you learn that way over a period of time, you are beginning to learn less and less. Because your first learning experience is huge, next one little less, and you begin to learn less and less. And if that is the way you have evolved as a lawyer, then you will find a lot of people who will still cry for milk and hope somebody will give it. I think the latter part of Mr. Chanaka De Silva's advice was about two things. He said about the skill and the mindset you need to have if you are to get that overall benefit. Now, that's a tough one, especially for lawyers, because we kind of tend to think that we know it all. So to unlearn and change your way of looking at things and bringing value to your clients, that's a completely different mindset. Now, once you have that mindset, it's a very distinct and a very powerful skill set that you need to get, which you obviously can't get in a short presentation like this. So if I may handle the 4 questions that I got. First is extent of the relevancy of negotiation in the legal profession and the attorney's duty to court. I think I answered that in my presentation in this way. Relevancy of negotiations is high, very, very high, because you're using your knowledge and your skills to bring more value to your client. And the more value your client gets, the more happy he's going to be with your services. And if you're interested in money, you're going to get paid more with less reluctance. In terms of your duty to court, court is one mechanism available to you to deal with your dispute. That's not the best mechanism. That's just one mechanism available to you. Now, if you do decide to go to court, I mean, if you do a contract, most contracts now have two dispute settlement clauses: mediation and arbitration, or mediation and courts. And if you look at construction contracts, it has dispute settlement boards and multiple mediation mechanism, dispute settlement mechanism. That is where people recognize that special problems need special solutions. So court is just one of those. So my duty inside the court, bound by rules of evidence and procedure and my own ethics, is different, but that does not impact my mindset. It should not impact my mindset that my ultimate aim is to get value for my client, but you need to do it within the law, within the ethical bounds and means. The second question that was posed to me is, should attorneys negotiate with clients prior to or during litigation? Should it be done prior to coming to court? My answer is an unequivocal yes. If you look at the procedure rules that are now been changing in the UK, they have said even the letter of demand should have enough information to demonstrate that you open through the letter of demand a channel for negotiation. And if you haven't done it, and if you have sent a letter of demand the type that we sent, where we just one paragraph and said, you owe me this much, if you don't pay me, I'll go to court. Once a judgment is given, that is taken into account in calculating costs. Whether the parties had a predisposition towards settlement of the dispute without waiting for a judgment of court. In other words, UK rules are now changing to encourage parties not to waste time and resources and lose value because of bad relationship. You see, when I cross-examine the other side, if I'm for the plaintiff, if I cross-examine the defendant, if I'm rude to him, if I'm insulting towards him, nothing will happen to me, but he will get angry with my client. And if I forget the fact that they are here because they have an underlying business arrangement, my effectiveness as a lawyer has failed. So, if you think that this dispute is something that needs to be negotiated within the framework that I gave you, and not something that you should be wasting your time by going to court, I would urge you to urge your client to initiate the negotiation. And at that time, if the client says, can I use your services, please volunteer, but change your mindset from being that gladiator in a courthouse to a problem solver, the joint decision maker, that you will do so when you sit across the table. What Mr. De Silva said about working in teams, I believe what team means not only your own team, but you team up with the other side also, because at the end of the day, you're trying to find a solution to a problem that both of your clients are experiencing. So, is negotiating with the opposing counsel's client a violation of ethics? It depends. Obviously, once a case has started, you can't directly go to the other client bypassing the lawyer. But if you have two lawyers coming in, there's nothing to stop them. Both lawyers are enlightened enough and see value and see themselves as an agent for value creation and not to harm your client. There is nothing stopping you, four of you, the two lawyers and the two clients, getting together and using this mechanism called negotiations to deal with their disputes. Fourth point, negotiations are used for unlawful and unethical purposes. Well, I would rehash it this way. Unlawful and unethical purposes are unlawful and unethical purposes. Whether you use negotiations or something else to do it, that still remains unlawful and unethical. So I wouldn't answer that question.
Okay, if I were to look at these questions, I would think I would agree with Harsha fully. Essentially, there is nothing wrong in negotiating a matter that is going to court. And in fact, negotiations are supposed to be encouraged. If you look at what's happening in the UK, if you look at what's happening in let's see, in the US, the rules require that you do that. And if you come to court without doing that, you will be penalized with very big costs. If you wrongfully refuse to negotiate, you will be penalized with costs. And if the court feels that you have been unreasonable in your negotiations, you will be penalized with costs. Right? Therefore, that is where the world is heading. So there is nothing wrong in negotiating. However, what is unethical, what is unlawful, and our rules are very clear as to what the ethics are and what is law. So you need to follow those. And of course, the most legal things are used for illegal purposes. We know that. Right? So you can't prevent that from happening. What you can prevent is yourself descending to that level. So keep your ethics. Keep to your ethics, understand them, know them, stick to them. That will look after you. Right? And please remember, I mean, these are professional seminars that we are conducting. Right? For a lawyer, what is most important is your professional reputation. So safeguard it as much as you can. Right? Then I did notice a couple of other questions coming.
So you had already answered one question. If you can share that with the audience as well.
Yeah, I'm going to read that. One question is, once you have worked as a negotiator, can you represent one party in court? The answer very simply is yes. As long as you're representing the same party. You can't negotiate for one party and appear for the other party. That won't be possible. Right? If you're representing the same party in court, that is definitely possible. Right? There is no issue. There is no conflict in relation to the matter. Right? You have brought about a contract. You're not a mediator. Please understand, a negotiator is representing a party's interest. A mediator or arbitrator is different. A mediator is actually looking after the interests of both parties and trying to bring about a settlement. Once you have acted as a mediator, it would be very difficult for you to take the side of one party, or even if you have handled the matter as an arbitrator. But if you have been negotiating for one party, you're representing a party, there is nothing which prevents you from doing that.
We have another question, sirs.
Yeah, how can we use this method to get sufficient compensation for victims of environmental pollution caused by express pearl? Well, I think the government is currently in that process, from what I understand. So what they need to do is basically sit across the table. I think that is the first thing to do in situations of this nature. Because running to arbitration or running to litigation is not something which is going to help. There will be insurance policies, there will be liabilities and which are established by principles of law. So you need to sit down with these people and see how you can achieve that. Now, even in order to do that, one needs to prepare yourself. So therefore, the internal preparation on the part of the government has to take place, not only the government, but all related parties. There are a multitude of claims which will arise in relation to them. You need to understand those claims. You need to collate the claims and be ready with them. You need to be ready with the legal principles which are involved, and on the basis of that, you have to carry on negotiations. So the answer to the question is it possible to negotiate? Yes, definitely. And I think that is the prudent thing to do before you rush to court.
I think there was another question they had asked, is the difference between bargaining and negotiations.
Yes.
So, you see, bargaining and negotiation, in my opinion, are two different processes. In bargaining, what happens is you take a position, normally on one dimension, say price. You stick to that position, and your whole effort is concentrating on defending that position. So, example, I want to sell a pen and I want 100 rupees for that. You offer me 80. I will somehow try to defend my 100 and you will somehow try to defend your 80. And at the end of the day, we might agree to do the deal at 90 and the net result is you're 10 rupees unhappy, I'm 10 rupees unhappy, and that's we call a classic compromise. In negotiations, what we do is we don't take a position, we try to understand what are our interests. The classic example is what Mr. De Silva said about the orange story, where if they took a positional bargaining, each would have wanted the orange. But if you're going for a negotiation situation, then you will ask the question, why do you need the orange? Then one would say, well, I want the seeds to plant it, I want the peel to bake a cake, or I want to eat the orange. Then you realize that you can actually come up with a solution that would satisfy the interest of everybody. Nobody feels that they sacrificed anything. You don't go through life compromising, but you go through life getting what you want. In a bargaining process, what you do is the assumption, your mindset is that the value is fixed, the cake is the same size, and your fight is to get a bigger piece. You're claiming value. But if you use the dynamic of negotiations, what you really do is you try to bake a bigger cake before you take your knife and start cutting it. So to do that, you need to work with the other side and figure out, hey, I'm sorry, you made a loss because I gave you the substandard supplies. I understand that. I'm sorry about it. What can we do to make it better? Maybe we can have a longer term contract and then I can help you to recover those losses over a period of time. You come up with different ways so neither party feels that they have to compromise, but they get what Mr. De Silva mentioned was a real win-win solution. Now, you will hear this phrase win-win when you study this area quite a lot. The problem is, most of the time when we say win-win, what we really mean is, I am going to win. If you win, good for you. But if you really develop your skill set, you can actually come up with a mechanism where you both can win. My question to you is, would it matter if you have got everything you wanted, you're very happy with the deal, and the other side is happier? Most of the time, we can't see that. We measure our success in relation to somebody else, in relative terms. And all that converts into the way we behave, way we approach, way we analyze the problem. So the court processes, arbitration processes encourage you into that behavior. So bargaining, courts, and arbitration kind of goes together. But looking at value creation, I would go with mediation and negotiations.
Thank you, sir. We have another question. Doing negotiations rather than not going to court or trial in the courts, whether it's unprofessional. Does negotiations, do they count as being unprofessional?
No, I don't think so. I don't think so. I think if you look at every commercial transaction, before parties end up in litigation, there is some form of negotiation. But very often what happens is these negotiations, or rather I would call it discussions. These negotiations or discussions are held in such an informal method and basically from very entrenched positions that they can't really resolve the issue, right? But if they do involve professional lawyers who can do that, or even other negotiators who can do that, there are others who can do that, not only lawyers. Right? You could probably achieve a better result. So is it unprofessional? Definitely not unprofessional. But if you drag it too much time, right, for such a long time that you become guilty of lashes and therefore you can't go into arbitration, or prescription runs against you and you can't go to court, that would of course be unprofessional conduct. So you need to be mindful of that. So that's the answer to that question. Harsha, anything you have to add?
I mean, certainly not, because you can also be an unprofessional negotiator, an unethical negotiator. You see, that's why I keep emphasizing the mindset. It's about what you want to get. So what happens is we tend to sometimes, I mean, practically, sometimes you might confront a colleague, a lawyer, who you feel is standing in the way of coming up with a deal that is good for both of you. maybe his fees has not got paid, or maybe his ego is in the way. You sometimes find that. And at times you're so frustrated that you're wondering, wish I could get a message to his client saying, get rid of this lawyer and come with somebody a little more enlightened, we can sort this out. You face that. But fortunately or unfortunately, our ethics rule prevents us from doing that. But that again is a you're stuck because of a method of getting that message across. But what I'm suggesting is, from the time the client comes to you, you should have the enlightenment to advise the client the nature of the conflict and show the client that it is in his best interest to come up with a different mechanism to resolve his dispute. Court is just one. And in that mechanism, if you are a skilled negotiator, you will become a very valuable person. I mean, face it. You don't see Mr. Chanakadi Silva in court often. But if you look at the number of transactions he has resolved or done, my guess is that's about good 1 year of court's work. So it's a skill set that you develop, and the ability to see the deal differently. That is what is important. So I wouldn't try to put a label saying doing negotiation is unprofessional or professional. It depends on how you define your profession. I define my profession as a conflict manager, a conflict doctor who offers a particular value addition to clients, and I will do it in terms of ethics. And if I use the method of courts, I will go with the ethics that are applicable to my role as a lawyer in a court. If I decide to be a lawyer and do it outside court, I will still be bound by the ethics that I'm supposed to follow as a lawyer. Those are not contradicted.
Thank you very much, sir. I mean, this has been a very interesting discussion, and I myself have several questions, but I don't know whether we will have enough time. Participants can direct if you have any other questions through Q&A box. Till we have further questions, I will direct one of my questions to you, sirs. I think Mr. Chanakadi Silva clearly mentioned that this famous saying where we say some deals are worse than no deals. I think when we say that, essentially we come to the importance of understanding what our best alternative and what's our worst alternative in a negotiation. So maybe I think, sir, if you can explain as to how you discuss these things with the client during at the preparation stage of a negotiation, and how that will help you evaluate whether a negotiation is necessary or whether you should go to court. I think that'll help all of us.
Okay, it's a very interesting question. I think Harsha basically said that I'm negotiating more than I actually am in court. I think that is quite true. If you look at the number of clients who come to me wanting to go to court, I actively discourage them from going to court. For one simple reason: if you negotiate with the other party and you arrive at a resolution of a dispute which is acceptable to both parties, the first thing is that resolution or that solution that you come up with is entirely within your control. You will agree to what you want, what you can afford, in the timeline that you can do it. And so will the other party. And very often than not, they will be able to go ahead and function. I'll give you an example of something that happened. Long time ago, probably 15, 20 years ago, there was, I mean, this particular business is still going on. 5 brothers were doing one of the most thriving businesses in this country. They had businesses all over. They had a fight. One brother went to court against the other 4 brothers and got a string of enjoining orders, essentially preventing the other brothers from functioning in the business just before a court vacation, like we often do always. And lo and behold, the other 4 brothers came to me. Then I told them what needs to be done, and I told them, look, you must take the petition. We have enough of time now, courts are on vacation. We'll have to file objections thereafter. So therefore, come up with your observations. And they had come with a set of observations. I have never seen perfect and complete observations like that. They gave me, each brother gave me a set of documents which would have ensured that they got the claim dismissed, and discussed with that. And at the end of that discussion, I told them, look, there's one thing you must remember. We will file these observations, go to court, get the case dismissed. And that will probably be the last time that you will speak to your brother. Right? Consider whether that is worth the fight. They were very silent for a little while, all 4 of them. And then they said, let's think about it and come back. And they came back, all 4 of them, and said, no, we decided we will eat our pride and go and work with our brother. And they had discussions and sorted it out. Even today, they are still in business, and they have a thriving business, not only locally, but internationally. Now, had I not done that, and I thought about, okay, I can make some money, go to court, fight it for a month or 2 months, probably good. I would have been in court every day for that. Right? They would not be in business today. Right? So that's a simple example of what you can achieve by negotiating. Right? And I think it was worked for everybody. They still are my clients. They come to me because they trust my advice. So did I lose in that game? No, I did not. Did any of those parties lose in that game? They did not. Now that is what you mean by win-win. Actually, I also won. Although I never went to court to represent them. Right? So this is what you need to understand when you're talking about negotiations.
Thank you, sir. One question to Mr. Harsha Fernando. Sir, you mentioned that it's always better to attempt negotiation prior to going to court, and that the trend now is that. However, sir, now in court, we often experience this, where the court sometimes suggests to explore the possibility of a settlement. And most often we see that at that stage, it's the lawyers who try to come up with these terms, and then finally they get it approved. What we do is we get it then approved by the clients. But can you explain us the importance of connecting with the clients even at that stage and having a proper negotiation, rather than coming up with settlement terms based on the positions that we came to court with, where we can enlarge the pie and then explore the interest and go through the process that you presented a little while ago? Why is it important?
Well, it's very. It's a very good question and a very important question you posed, because if you look at a case now, you get clients at different stages. If a client wants to file a case, or if they want to, even if you file a case and if you want to initiate a negotiation while the case is pending, we advise them to do so before the answer is filed, if possible. The reason is, moment the answer is filed, the word you used was, their positions get frozen. And then if you look at the traditional law, when it comes to issues that you raise issues, then you further narrow it. And the more you narrow it, it goes sort of against the concept of creating value, because you narrow it, and you finally narrow it to a few things. Now, when the lawyers get involved, what happens is we tend to negotiate within the confines of that brief. Because if you go step outside, and especially if you don't understand the business model, supposing if it's a business client, a business dispute, and if you don't understand the business model, the risks involved, the cash flows, understand the business model, but only you take a narrow view of the conflict in court, then you will not have the confidence, and I don't think you should try that also, unless you fully understand the deal to come up with a deal. As a result, we tend to take the easy way out, or the more comfortable or more safe way out, and limit ourselves also to that framework that the positions already filed in court confines us to. So I think it's absolutely important that you try to move out of that and encourage the clients to see beyond that. So one of the good things, and especially in the US now, they have what we call like the negotiation or mediation under the authority of the court or under the supervision of the court. So they are then both knows where they are sort of the issue is crystallized. So you take that as the last point, and everything beyond that is a win for you anyway, because that's your least. So in a situation like that, I think it's absolutely critical, because to recognize that we may not have the knowledge and the overall understanding, and that we should defer to the client and to his business interests, which may not come out in the pleadings, in the case. But our challenge is, as Chanaka mentioned, to strengthen the client, to encourage him, to get him to see the deal differently. I mean, no lawyer would tell his example about, I think I can guess the 5 brothers you are talking about. No lawyer would ever say that, because, I mean, if you went to litigation, I mean, you're going to be a very rich lawyer. But the fact that he posed that question gave them a different reality than what they thought it was. Now, the fact that he posed that question, as Chanaka said, had multiple benefits. The regard they have for that legal advice, I don't think Chanaka would have got even if you had won 10 cases, because they trust him, not only them, even the other side. So that shows you. So the lawyer's duty is to show your client. I mean, are you somebody who is going to react to what your client says, or are you going to somebody who is going to shape the expectations of your client in a realistic manner? Choose your role. Don't be that guy who the only tool you have in your toolkit is a hammer, because then every problem becomes a nail. So every problem you get, you say, let's go to court. Won't work.
Thank you very much, sir.
That being said, there is also merit in sometimes using court as a strategy for settlement of a dispute as well. Right? Litigation can be a strategy for settlement of a dispute. So you need, like I think Harsha said that very clearly, identify when you need to go to court, or for what purpose you need to go to court. Right? Because you might be able to catalyze the settlement by going to court, right? Which you may not be able to do otherwise, right? So you have both sides to it.
Thank you very much, sirs. I think we all have so many questions, but the time is a challenge for all of us. But I'm sure that this session gave a lot of insight as to what negotiation is, and how lawyers can be negotiators, and how that can actually be a hat for us in our profession, and qualification and an added service to our clients. Thank you very much, sirs. On behalf of the BASL Seminars Committee, I extend our greatest gratitude to Mr. Chanaka De Silva, President's Counsel, and Mr. Harsha Fernando for your valuable commitment that you made today despite your busy schedules, and the great insight that you shared with us. I would also like to thank all of you who joined us through Zoom and YouTube, and for your questions that made this webinar an interesting one. Thank you, everyone. I invite all of you to join us again next week on Sunday at 7 p.m. for a webinar on a different and an interesting topic, just like today's. Thank you and stay safe.
Thank you very much.
Thank you very much. It was a pleasure joining this.